The African Transformation Movement is heading to the Constitutional Court on an urgent basis, seeking clarity on the implementation and effect of the Constitutional Court's earlier ruling on the Section 89 impeachment process. This follows last week's Western Cape High Court judgment, which granted President Cyril Ramaphosa an interim interdict preventing Parliament from proceeding with public hearings of the impeachment inquiry. The ATM argues that the ruling has created constitutional uncertainty, particularly as the decision was not anonymous, with a dissenting judge finding that the president had failed to make a proper case for interim relief. Joining us now to discuss this ruling and what it could mean for South Africa's constitutional democracy, we are joined by legal analyst Bophelo Seleke. Good afternoon to you, Bophelo. Are you surprised at all that perhaps the ATM is seeing a loophole, or do you think that perhaps this is a misunderstanding on their part?
Good afternoon. I'm not surprised at all. ATM would be relying on a right that is available to every citizen in this country, including organizations or juristic persons in the form of political parties or other NGOs, in that if they are of the opinion that a judgment that had been handed down, where they are party to its litigation, did not perhaps appreciate the full facts before coming to a decision, there is a mechanism in which they can exhaust, which is an appeal or, in some instances, a review. But I think part of my being surprised is that the matter seems to have evolved beyond a dispute about President Cyril Ramaphosa, but it has now become a constitutional test of the relationship between the judicial process, parliamentary accountability, and the rule of law. So the immediate question is whether the Constitutional Court should urgently entertain ATM's direct appeal against the Western Cape High Court's decision to grant President Ramaphosa's interim relief.
So, I mean, for me as a layperson, it appears as if there are crossroads here where the president has a right to review and where the impression that we were given by the Constitutional Court was that the process must continue, albeit it must be done properly. So how do we then find the understanding between those two particular crossroads?
The answer lies in the Western Cape High Court judgment. So, one, it would be incorrect to say the Western Cape High Court has overruled or suspended the Constitutional Court's judgment, the earlier judgment. That would be legally incorrect. But what we need to understand is the Constitutional Court's judgment, even at this stage, remains fully binding. The High Court could not and did not suspend or vary any order of the Constitutional Court. Instead, the full bench of the Western Cape High Court did the following. They provided or they granted an interim interdict directed at Parliament's implementation of aspects of the Constitutional Court's earlier judgment, while the President's review proceedings are still underway. Now, that distinction is fundamental. So the Constitutional Court's judgment still stands. The interim order simply regulates what Parliament may do while another court determines the legality of the President's review challenge.
So, I mean, just in simple terms, I mean, what will the Constitutional Court be looking, or what would be the attitude of the Constitutional Court in terms of this matter by the ATM?
So, in terms of approaching the Constitutional Court on a direct access basis, the ATM, as a party that's bringing the matter, really has a high hurdle to overcome. And among the considerations that ATM has to convince on its papers the Constitutional Court is that the dispute raises constitutional issues and that the appeal that they seek will enjoy a reasonable prospect of success, that the matter is urgent, and whether bypassing the Supreme Court of Appeal is justified. So they need to provide a reason for that. And whether the interim order has sufficiently serious practical consequences on the part of the case of ATM and the other parties that are allied to it, in terms of the implementation of the earlier Constitutional Court judgment in terms of the Section 89 process. And lastly, they need to convince the Constitutional Court on whether intervention serves administrative justice or is in the interest of justice. And this is a demanding threshold that the ATM needs to overcome in order for them to approach the Constitutional Court on a direct basis. But what maybe is the question that why are they not appealing perhaps at the Western Cape High Court? It's I think simply put, interim interdicts are generally not appealable, and that is because they are temporary measures. So they do not finally determine the rights of the parties. What they simply do is to say, while another case is being made out elsewhere in a competent court, and in this instance, it's the same court that will be hearing the review application of the president. We are then staying the proceedings. We're not overruling any Constitutional Court order judgment. We are saying, hold off on implementing fully the Section 89 process as a committee until a court that is competent or is currently hearing the appeal or the review, application, decides on the merits of that review application, and then the outcome of it will inform how to continue.
Do you think that would be possibly the approach of the Constitutional Court to say, but we have not even gotten into the merits of the case, which is still coming in September? Perhaps that's what you should be doing, waiting for that particular issue to be ventilated before coming to us to start to challenge anything that comes out of the courts. Is that how probably they will approach it, or do you think it's a simplistic way of looking at it?
I think we would have heard part of what the Constitutional Court will anticipate to hear when ATM brings its application formally and reviews its papers. And I must point out that ATM's strongest point may not lie in the politics, but in the existence of the minority judgment that came out of the Western Cape High Court. Let's put it in this context. Ordinarily, an applicant seeking to appeal must persuade a higher court that another court could reasonably arrive at a different conclusion. Now, the Western Cape High Court, with its recent judgment, I think on the 24th of July, has effectively arrived at a different understanding or application of the material facts. Remember, there would be a majority judgment as well as a minority judgment. Now, Justice Davis produced a comprehensive dissent. That's the minority judgment that was endorsed by another justice. But essentially, it was explaining why the president's application should have failed. And in one instance, the court actually goes out to say, arguing irreparable harm is the inevitability of this process. I mean, once the president does appear, if he will appear at the Section 89 impeachment committee to answer questions, the reputational damage that may come out of that is something that the president simply has to contend with. So that cannot be a leg that the president stands on. So the ATM, in bringing this application, my view is they will likely argue that the dissenting judgment that came out of the Western Cape High Court demonstrates that the constitutional questions are genuinely arguable and therefore deserving of consideration by South Africa's highest courts.
Well, let's leave it at that. As always, thank you so much, sir, for your insights and your time. That was a legal analyst, Bophelo Seleke.